Good morning. It's a pleasure to be with you today. Our topic today is how to terminate employees and not get sued. I wish I could stand here today and say, if you follow the instructions I'm about to give you, that you cannot be sued by a fired employee. I also wish I could say I had a cure for my baldness and that I found Bigfoot. But I think there's about the same likelihood of all three things ever happening. I wish there was a bulletproof vest that I could give you to put on that could keep you from being sued by a fired employee, but there isn't. So an alternative topic, title for today's topic is this: what should you do to maximize your chances of not getting sued by that employee that you're going to fire or have fired? And what can you do to maximize your chances of winning the lawsuit if one is filed? So here's a theme for today's talk. To avoid a lawsuit by a fired employee, how you fire an employee can be as important as why you fire them. How you fire is as important as why. So today I'm going to focus on the how you fire and not the why. I'm not going to focus on whether or not you should fire an employee. I'm going to focus on how you should implement the firing decision that you've made. So let's say you're going to fire an employee named Sally for poor job performance. Why do I pick a female? I've been doing this for almost 32 years now, defending employers. I've defended public sector, private sector employers in literally hundreds of lawsuits filed by fired employees. In both the public, private sector, all size companies in the private sector, if there is a typical plaintiff that I've seen over the years that challenges their firing, it is this: she is female. Probably 60 to 65% of the cases I handle are filed by females. She's in her 30s or 40s, and she has a very strong personality. So, let's say you're going to fire an employee named Sally for poor job performance. Let's say Sally has some suspicions that maybe she's being subjected to some kind of sex discrimination. So let's focus on what you should do during three different time periods. First, before the termination meeting. Second, at the termination meeting, and third, after the termination meeting. There's one overriding principle that should guide all the things you do during all three of these phases, and it is this: when firing an employee, doing it in a way that allows them to preserve their dignity and avoid embarrassment will go a long way towards helping you avoid a lawsuit. Let me give you three examples of Oregon employers that did not allow an employee to avoid embarrassment in the course of the firing. These facts all come from recent Oregon cases. The first one is what I call the airport firing case. It's the Araujo versus General Electric Information Services case. And in that case, while Araujo's supervisors decided they were going to terminate his employment. So while Araujo and his family were at PDX, waiting to fly out of town on a family vacation, the supervisors drove to the airport, met him in a restaurant while his family waited out in the hall waiting to go through security, and they fired him in the restaurant. Then they tried to forcibly take his laptop, his company laptop, away from him. Well, obviously he was embarrassed in front of his family, and so Araujo sued, claiming every conceivable legal theory possible, including the intentional infliction of emotional distress. The employer eventually won that case, but only after it went all the way up to the Ninth Circuit, and after the employer paid a lot of money in attorney fees to win the case. Second case is the Campbell case. It's what I call your kids won't have a mother case. Campbell was a cashier at a grocery store here in Portland. Campbell's supervisor believed that Campbell had stolen $800 out of the cash register. So the supervisor had loss prevention in the store, interview Campbell. So loss prevention employee took Campbell to the store manager's office. Campbell denied taking the money out of the cash register. And so the loss prevention person then proceeded to block the door to the office so Campbell could not leave, and then said that he would, quote, kick her ass if her attitude did not change. Then he said, and if, Campbell, you ask to see any proof that we have of your theft, you will immediately be taken to jail, and because you're a single mother, your kids will be left without a mom. Campbell ultimately signed a confession, was fired the next day. Campbell sued for false imprisonment and for intentional infliction of emotional distress. The grocery store moved to have the case thrown out, and the court denied that and allowed the case to go forward to trial. And in the course of doing that, the court said that the loss prevention guard browbeat Campbell based on scant evidence, if any, of the theft that she was accused of having engaged in. Third example of an employer that did not avoid undue embarrassment to an employee when they fired him is the Patton versus Target Corporation case. Patton worked at the Target distribution center down in Albany. Patton took a 2-week leave of absence to attend National Guard training, came back to work, and shortly after he returned, he was fired. And in the court's opinion, it says that the employer escorted Patton out of the building after the firing on a circuitous route that forced him to walk past all of his former coworkers. He sued for violation of USERRA, the Uniformed Services Employment and Reemployment Rights Act, and basically Patton claimed that he was fired in retaliation for having gone off on a 2-week leave of absence for National Guard training. Patton won that case, and a Portland jury awarded Patton $985,000, including $900,000 in punitive damages. Interestingly, Target has a case pending against them right now down in San Diego, and the allegation in the case is that Target has a policy, a practice of using the walk of shame when they fire employees. And in that case, the employee was fired, was forced to do the walk of shame, committed suicide 3 days later, and the family is suing Target right now. So watch the papers for what happens in that one, case down in San Diego. So avoiding undue embarrassment when you fire is extremely important and may help you avoid a lawsuit. All right, so let's talk about what you should do before the termination meeting. First, obviously, for those public sector, almost all of you are public sector employers. We have a few private sector employers here. Provide any necessary pre-disciplinary hearing per the Loudermill case. I think you all know about this. Basically, it says when a public sector employee has a property interest in their position, and a property interest, for example, if you have a unionized employee and your union contract says you have to have cause to fire, the employee has a property interest in their position. So when you have a public sector employee who has a property interest in his or her job, Loudermill requires the employer to give the employee the following 3 protections before the disciplinary decision is made. Number 1, you have to give the employee a notice of the charge or charges against the employee. Second, you have to give notice of the potential sanction that could flow from the misconduct. And third, you have to give the employee a meaningful opportunity to respond to the charges. So that's for your unionized employees. For non-union management and for those in the private sector, you do not have to give Loudermill pre-disciplinary hearings. So second, before the termination meeting, you need to decide the logistics of the termination meeting. Where is it going to take place? When is it going to take place? Interestingly, I find when employees quit, it tends to be on Monday morning because they had the weekend to think about what they're going to do. They have another job offer or whatever. I tend to find that quits happen on Monday mornings, and firings tend to happen on Friday afternoons because you don't want them around anymore, right? You want them to be out of the workplace. So that's a when. What about why? We've already decided that we're going to fire Sally for her poor job performance. And who will be present? Obviously, very important to have a witness present at the termination meeting. And the reason is because, believe it or not, in virtually every case I have, there's a dispute about what was said to the employee at the termination meeting. It's always best to have 2 people there from management so that it's 2 against 1 in the testimony in the case as to what was said during the termination meeting. Third thing I like to have you do then is to write out the reasons for the termination. By writing them out and putting them down on paper, it forces you to think through the reasons, and it forces you to be very clear and succinct about what the reasons are. It's very important at this phase that you consult your attorney or whoever else you talk to about such things, because you do not want to include, obviously, any illegal reasons or anything that would impact it or any reasons that might cause you problems down the road. For example, if you're firing an employee for absenteeism, you obviously don't want to count the FEMLA-protected or OFLA-protected absences. So consult whoever it is you need to consult about what the reasons will be. Also, when you're writing down on the script what the reasons are for the termination, consider broadening your list of reasons for the firing beyond just the immediate triggering event. Here's a common situation. Sally has engaged in poor quality job performance for quite some time, and so you decide that you're going to fire her. But about a year ago, 9 months ago, she had an incident of insubordination. Sally yelled at and swore at her supervisor. You maybe even gave her a warning for it at the time. Consider adding the insubordination as an additional reason for the firing decision. Why? It's because if you don't add it as a reason, you may not be able to get it into evidence at the trial that may happen down the road. Here's what I mean. You generally cannot put into evidence just the fact that an employee has bad character or that they're a bad person. That kind of evidence generally is not admissible. What is admissible is what your thought process was and what your motivation was for the firing decision. So if you add not only Sally's poor job performance, but also her insubordination, you're guaranteeing that you can get the insubordination into evidence as well. And why is that important? Because when judges and jurors consider cases, they like to do what's fair and what's just. They don't care what the law says for the most part. They like to do what's fair and what's just. And so at a very gut level, jurors don't want to find in favor of a bad person, whether that bad person is Sally or whether or not it's Sally's supervisor. They don't like to find for bad people. So as the employer's lawyer, I want to be able to introduce evidence that will show the judge and will show the jury that Sally was not the kind of person that they, the jurors, would want to work with in their workplace. So very important, if you can broaden your list of reasons beyond the immediate triggering event, it can really help your case. Again, remember that you can't put any of the additional reasons if they have anything that contaminates them in any way or would make it more difficult for you. You do not want to add them in. But always consider broadening your list of reasons for firing beyond the immediate triggering event. Next thing to do before the termination meeting, write a script to use at the termination meeting. If you're doing a pre-disciplinary Loudermill hearing, write the script for the Loudermill hearing. But write a script down. And the reason is you can summarize the points you want to make. You can just put them in bullet points. It doesn't have to be anything extensive. But again, employees often dispute what they are told at the firing meeting. And if you have your script, I can put that into evidence and say, so is this exactly what you talked about, what's on this script? Yes. And it tends to undermine the employee's testimony. Well, they also talked about my workers' comp claim, and I think they really fired me in retaliation for the workers' comp claim. I can put that script in and say, well, there's nothing on here that talks about workers' comp, is there? Well, no, there isn't. So writing a script can be really a very helpful thing. Summarize the points. That's what we just talked about. Now, next issue is, should you tell Sally at the termination meeting, and should you put in your script so you can talk about it at the termination meeting, should you tell Sally why she is being fired? Again, if she's a unionized employee, the Loudermill requires that you tell her the reasons for it, but for your non-unionized management people or for any at-will employees that you're going to fire, I get this question all the time. Should I tell an at-will employee the reasons why they're being fired? And should I put the reasons in the script? My answer is yes, absolutely. You should always tell an employee why they're being fired for 4 reasons. Number 1, there are cases decided by the Oregon Supreme Court, Oregon Court of Appeals, and by the Ninth Circuit Court of Appeals that say if you don't tell an employee why they're being fired, it constitutes some amount of evidence that when you identify later in the lawsuit the reasons for the firing, the fact that you failed to tell Sally at the termination meeting undermines the credibility of what you're saying later. That's the first reason. Second reason you should tell Sally is what I call the vacuum principle. If you don't tell Sally at the termination meeting why she's being fired, there is a vacuum of information. Nature abhors a vacuum. Remember that from science class? Nature abhors a vacuum. If you don't tell Sally why she's being fired, Sally is going to fill that vacuum of information with a reason that she likes and that you won't. I guarantee you won't like the reason. So, for example, even though you may have given Sally progressive discipline for a bad performance for months and months, Sally isn't going to think that there's anything wrong with her performance. Sally is going to latch on to a reason for her firing that is based on something that she recalls that happened. If she complained about not getting a break 6 months ago, if she complained about not getting paid overtime 4 months ago, she is going to think, if you don't tell her why she was fired, she is going to rationalize away her poor job performance, and she's going to latch on to that as, oh, I must have been fired in retaliation for complaining about not getting breaks or complaining about not getting overtime pay. So she will fill that vacuum of information if you don't tell her why she's being fired with reasons that you are not going to like. And then another reason is jury sympathy. Jurors, the average rank and file person that sits on a jury, how many of you sat on juries? Anybody been kicked off? You got in there and they found out you're an HR person, they kick you off? I always kick off HR people off the jury. And the reason is because you'll be more critical of the HR person that I'm defending for them not doing something right. I always kick HR people off the jury, and employees often do as well. But, so the people that sit on juries, they don't understand the at-will rule. They think you have to have a reason for why you're firing them, and it's got to be a good reason. And they think you have to tell the employee why they're being fired. And they don't understand it. Why in the world you would never tell an employee why they're being fired? So jury sympathy can work against you if you ever get as far as a trial, so I think you need to tell the reason. And the last is, right now pending in the legislature, there is a bill that would require you to tell employees why they're being fired. It's in your materials. It's Senate Bill 718. I don't know if it's going to pass or not, but it's possible it could, and it might require you to give reasons. All right, we're still before the termination meeting. We're talking about writing a script. When you write your script, tell the truth in your script and don't pull your punches. The tendency we all have, nobody wants to sit across the table from an employee you're fired and say they're a crappy employee and they're bad. No one likes to do that. It's not, you know, we have this natural tendency to pull our punches and not lay out all of the full reasons why somebody's being fired. Well, here's the problem. That results then in what's called the shifting reasons problem. Here's a situation I get all the time in my cases. We're at the termination meeting, and Sally is told that the reason for firing is, you know, you're just not a good fit, or we're going in a different direction. Any of you ever said that before to an employee? That kind of stuff is going to hurt you. So let's say at the termination meeting we have reason A, which is you're not a good fit. Then it has to be recorded in the personnel file, and so the supervisor writes something down a little bit different in the personnel file, maybe fleshes that out, maybe goes in a different direction totally. Now you've got two different reasons for the firing. One is what's said to Sally at the termination meeting, and the second is what's said in the personnel record. Then Sally files an unemployment claim, and now you got to send a form back in to the employment department, and let's say you put a different reason in the unemployment, because now, well, geez, you know, maybe I got to write down more of what than I gave before. A lot of times my clients have somebody different filling out the unemployment form than the supervisor that did the firing. And sometimes they don't get the word. The person that fills out the unemployment form doesn't get the full word. So now we have three kind of different reasons that we've said over time for the firing. Then she goes to BOLI and files a BOLI claim, goes to EEOC. Now you got to make sure you got down in writing what the real reasons are, and either you or your lawyer fills out the position statement response to BOLI. Well, the problem is, even though there was no evil motive here that any of you had for what you laid out the reasons were on 4 different occasions, but you've got 4 somewhat different versions of what the reason was for the firing. And the courts say where there's this inconsistency over time in stating what the reasons are, where you shift, where your reasons for the firing shift over time, it virtually guarantees that a lawsuit that Sally fires over her firing is going to make it all the way to trial, and you won't be able to get it bounced out short of trial. So the bottom line is, it's almost always best to tell Sally all of the truthful reasons for why she's being fired, and to write those reasons in the script that you're going to prepare for the termination meeting. Number 5. When you're getting ready to fire somebody, I'd like you to consider whether or not to have Sally sign a separation agreement. Separation agreement basically says a couple things. It says what the employer is going to give Sally, and it says what Sally is going to give the employer. And what you're looking for from Sally is a release of her rights to sue you. Okay? How many of you use separation agreements when you fire employees? A fraction. I'd like to have you at least consider using a separation agreement every time you fire an employee. What are the things that you can give to Sally to make one of these separation agreements enforceable? Well, number one is severance pay. There's no federal law, there's no state law that says you ever have to give severance pay to an employee. If your policies say you will give severance pay, then you're contractually required to do it, but why would you have a policy that says that? So, absent a policy requiring severance pay, if you give her severance pay, that's something she's not otherwise entitled to, and that would make a separation agreement enforceable. Another thing you can give Sally, you can say we won't actively contest your application for unemployment benefits. You know, the deck is stacked against you anyway with unemployment. The chances of you winning are not that great unless the facts are really bad. For mere poor job performance by Sally, you're probably not going to win that unemployment claim. So why not give her a promise that you won't actively contest her application for unemployment benefits? Now, you can't promise that she'll get them because you don't control that, right? And furthermore, you always have to tell the truth to the unemployment people. You cannot lie. It's perjury if you lie. So you need to tell the truth. So if responding to an application for unemployment benefits, you put down the reasons for firing, and Sally could view that as contesting her application for benefits, you need to be careful about what the separation agreement says. But there is language that I use in a separation agreement that you can say we won't actively contest or language like that. You can give her a letter of reference. Never give a letter of reference to Sally before she signs the separation agreement. Because if you give her the letter of reference, she doesn't sign the separation agreement, she files a lawsuit. Exhibit A in the lawsuit is this letter of reference that you just filled out. So never give her the letter of reference until after she signs the separation agreement. You can pay her COBRA health insurance premiums. Nothing stops you from paying that for 1, 2, 3 months, whatever you want to do. And that's a huge bargaining chip in today's world because the cost of health insurance is so great. And you can agree to pay buy outplacement assistance for Sally so she can find another job. What is it that we want to get out of Sally? There's a couple of things. Number one, I always like to get a resignation. If it's possible to get a resignation, I'd like to get it. The Sallys of the world often will not agree to resign their employment because they know if they resign, it's harder to get unemployment benefits when you resign, because then the burden's on her to show she resigned for good cause, whereas if you fire her, the burden's on you to show that you fired her for misconduct. So many employees will not give you a resignation. That's not a deal breaker for me, but I always like to ask for it. Get Sally to promise never to reapply. What's the worst thing that can happen is you fire Sally, you pay her a little bit of money to go away, and then a month later she comes back and reapplies for an open position. You're not going to hire her. She's then going to claim, you didn't hire me in retaliation for my prior claims that I thought I was being subjected to some kind of illegal conduct. So you're going to be back in the same position you're in now. So always get a promise to never reapply for work. We call that never darken the doorstep clause. Okay. With some employees, it's important to get a promise that they will never disparage us in the future. You may want to get that. Release of claims. This is a deal breaker. This is what you got to get. I would never give an employee money to walk out the door unless I got a release of their rights to sue not only the employer, but you and all other employees of the employer. A couple problems here. There are some claims that are not releasable, that can never be released. Workers' comp claims can never be released in one of these agreements. Unemployment claims can never be released in one of these agreements. Fair Labor Standards Act wage and hour claims have to go through a very complicated process to get released, so you may not be able to get an effective release of that. You can't stop Sally from going to the EEOC or BOLI. You can't stop her from participating in an investigation by BOLI or EEOC. You can stop her from getting money. She can't agree not to take any money as part of a subsequent EEOC or BOLI claim. And then if you want to get a waiver of age discrimination claims, there's some specific language you have to put in the agreement to stop that. So, should you ask Sally at the termination meeting, should you prepare to ask her to sign a separation agreement? I think you always need to consider it with every employee. The positives are it gives you peace of mind that Sally's never going to come back on you and sue you again, which is great. The negatives, I can think of 4. Number 1, with some employees, asking them to sign a separation agreement at the termination meeting is like waving the red flag in front of the bull. And if they thought, the thought process Sally sometimes has is, why are they trying to get me to waive my rights unless they know they're violating my rights? Maybe instead of walking down the street to my lawyer, maybe I better run to my lawyer. That's why I think it depends on Sally's personality. Only you know Sally's personality and whether or not it would be the right thing. It is the right thing to do with some employees. With other employees, it's not the right thing to propose. Another negative is that if you ask Sally to sign a separation agreement, you give her a copy of one, she doesn't sign it, she sues you, the separation agreement could be admissible in evidence down the road. There's a Ninth Circuit case right on point that says it probably is admissible. So, of course, Sally's lawyer at trial is going to hold up the separation agreement that you proposed and going to say, why would the employer have asked Sally to sign a separation agreement waiving her rights unless they knew they were violating those rights? That's the downside if she doesn't sign the separation agreement. And then the last downside I can think of is in the public sector, separation agreements are not necessarily confidential. Freedom of Information Act requests may require you to disclose that. So the bottom line is it depends on Sally's personality on whether or not you ask her to sign a separation agreement, but I would like you to consider it every time you fire an employee. Another thing to do before the termination meeting, preserve evidence. Preserving evidence is a wise thing to do if you think Sally might possibly file a claim against you down the road. Preserving evidence is required if Sally has already put you on notice that she is going to bring a claim against you or might bring a claim. And this is what's called the spoliation issues, the destruction of evidence. If you destroy evidence, even accidentally, if emails get lost, if your computer backup tapes aren't kept, things like that, and that evidence then becomes relevant down the road, the judge can instruct the jury that the evidence that was destroyed, even accidentally, that the jury may presume that the destroyed evidence was good for Sally and bad for you. And that's a very bad instruction. You don't want to have to deal with that. Things you should preserve, paper documents, obviously, electronic evidence, computer records, emails are the number one piece of evidence that we use in our employment cases nowadays. People say incredible, amazingly stupid things in emails, both employees and supervisors. It's the number one piece of evidence that we use. If after you fire Sally, you're going to give her desktop computer or her laptop over to somebody else, why not just make a mirror image of the hard drive before you reissue that computer to somebody else? Then you have captured all of the evidence in her computer, so you can give that computer to somebody else and don't have to worry about evidence being destroyed. Cell phones. A lot of times, company-issued cell phones, employer-issued cell phones come back in. I found amazing evidence on cell phones. I've had 2 recent cases where female employees claim that they are being sexually harassed by their supervisor. I get a hold of their cell phone, I look at the pictures on them, and on both cases I found pictures with the woman draped over the alleged harasser in a bar, and just the looks on their face was just total delight. So that was tremendous evidence to use to defeat the sex harassment claims. All right, at the termination meeting, what should you do? What if Sally shows up with a friend? All right, well, if Sally's in a union, she may have the right to have her union representative attend per the Weingarten rule and per Erb rules. She may have the right to have, now if all you're doing is communicating the termination decision, she may not have the right to have the union person there. But if you're doing more than that, she may have the right to have the union rep there. Non-unionized employees, at-will employees, they oftentimes show up with a friend, a coworker, somebody else they'd like to have sit in on the termination meeting. I tell clients it's not required that you let that person sit in, but unless you have reason to believe that friend is going to disrupt the proceedings, why not let them sit in? It makes it look like you're not nervous. You're not worried about what's going to happen. You're not worried about any kind of lawsuit. Use the script. Follow the script that you prepared at the termination meeting. Now, a lot of times clients ask me, you know, we do want to ask Sally to sign a separation agreement, but we don't know how to propose it to her in a way that doesn't look like the very thing we're worried about. She's going to think, why are they asking me to waive my rights unless they know that they're violating my rights? Here's the pattern that I tell my clients to use to propose it. You know, Sally, we'd love to help you out financially. You've been with us a few years. We'd like to help you out financially here until you can find another job in the next few days. But, you know, Sally, nothing requires us to give you any kind of financial package at this point. You know, we'd be willing to talk about maybe giving you some severance pay, maybe covering your COBRA premiums for a month or two. But, you know, you recognize, Sally, in today's world, if we don't have to give these things to you, but we do give them to you, we got to get something back. That's just the way it works, you know, in today's world. And so here's a separation agreement. Take it with you. Think about it. You know, if you'd like to sign this agreement, that's great. We can pay you the money that's talked about in the agreement. If you decide not to sign it, that's fine too. It's totally up to you. Something like that is a good way at the termination meeting to present this separation agreement. Get your stuff back, whether that's keys, computers, access codes, credit card, whatever it is, the company property that Sally has. Give Sally the final paycheck. If you have not in your collective bargaining agreement bargained away what Oregon law says about the final paycheck, Oregon law says you have to give Sally, because she's a fired employee, you have to give her the final paycheck on the next business day after the firing. I've had clients call me saying, we fired Sally yesterday, I've sent somebody with her final paycheck over to her house today, and we know she's in there because we can see the curtains rustling when they knock on the door, and we know her car's in the driveway, but she won't open the door. Well, Oregon law says you have to give Sally that final paycheck by the next business day. Sally doesn't have to open the door. And so I tell my clients, if you can, have the final paycheck ready at the termination meeting. It's just a lot easier. You'll save yourself lots and lots of hassles if you can have it ready at the termination meeting. Remind Sally of any ongoing duties she may have. This is less of an issue in the public sector. In the private sector, you may want to remind Sally that she signed an arbitration agreement. She signed a confidentiality agreement. She signed trade secret agreement, things like that. You may want to even give her a copy of those things. Let Sally get her personal belongings. This is a big deal. It doesn't sound like a big deal, but it is. You know, Sally wants her stuff back, and she doesn't want to go back in front of all her coworkers and empty her desk out in front of everybody. So make arrangements that she can come in, you know, at night on a weekend with somebody there to supervise her. Maybe she's got a friend that works there that would be willing to empty her desk out and get all of her personal stuff back to her. COBRA notice, if you can give the COBRA notice at the termination meeting, that's great. Not required, but if you can, that's great. All right, what should you do after the termination meeting to maximize your chances of avoiding being sued? Number one, what should you tell the other workers about Sally's departure? You should assume that that somebody that's still working for you is going to tell Sally what you told employees about Sally's departure. So as I found that employees understand that you are not going to tell them why Sally's not there anymore, because they wouldn't want you talking about them if they were gone. And so they understand that you really are not going to be telling them about why Sally's not there. But there may be some situations where you need to tell employees. If you can limit the scope of who gets told about why Sally is not there to those employees who have a need to know, that's the best. And when you tell them in writing, because then there's no dispute about what you said. Number two, responding to Sally's unemployment claim. Here's the typical situation. You fire Sally at the termination meeting. She's mad. She maybe makes some comments. I'm going to sue you. Maybe just make some veiled comments that show she's so upset. After the firing, the first thing that often happens is you get the unemployment claim in the mail from unemployment. And you have to decide whether or not you are going to fight Sally's unemployment claim. I'd like to have you avoid the knee-jerk reaction to automatically say we aren't going to fight it or automatically say we will fight it. I'm going to give you 4 reasons why I think you should fight an unemployment claim, and then I'm going to give you 4 reasons why I think you should not, and I think you should consider these factors anytime you're trying to decide what to do about an unemployment claim. Here's 4 reasons why I think you should fight Sally's unemployment claim. Number 1 is what I call early discovery. The unemployment hearing, as you know, is done by phone, and it is recorded on the ALJ's end, and Sally is placed under oath to tell the truth. It is a tremendous opportunity to ask questions of Sally at the unemployment hearing about why she thinks she was fired, about her misconduct, things like that, because it's often at a time, the hearing takes place at a time, before Sally's really prepared to testify and talk well about her case. I've gotten amazing admissions out of employees when I do the unemployment hearing for clients. I had a case a couple years ago that went to trial. My best piece of evidence was Sally's testimony at the unemployment hearing, where she told a different story at the unemployment hearing than what she later told in the trial. And it's a tremendous piece of evidence. Second reason why you should fight. Even if you lose, it's not admissible in court. So what's the downside of at least trying it? Third, you send a message to Sally, we are not going to roll over, and we are going to fight you. So if you're thinking about filing a lawsuit, we're going to fight you every step of the way. So you send a message. And then another reason is you might win, and you keep your experience rating down. So the next time you renew your unemployment insurance, your experience rating is lower, your premium is lower, and you save money. Here's 4 reasons why you might not want to fight the unemployment. Number 1, just as Sally often testifies without being prepared, your people are going to testify, and they may not be fully prepared and ready to testify. And they're under oath just as Sally is. In that case I told you about a minute ago where my best piece of evidence was what Sally admitted at the unemployment hearing, my worst piece of evidence was the HR person's testimony at the unemployment hearing. She had previously arranged to play in a charity golf tournament on the same day as the hearing. She didn't want to give up the charity golf tournament, and so she testified by phone, on her cell phone, sitting in a golf cart, zipping around the golf cars during the unemployment hearing. She didn't have her file in front of her, and she really couldn't hear that well, and she testified, and that ended up being, her testimony ended up being the worst piece of evidence that we had to work around. So just as it's a good time to depose, it's a good time to get Sally under oath, it's a bad time to have your people under oath. What I try to do in unemployment hearings, I just show up by phone and I don't have any of the employer's witnesses, and I just question Sally on the phone. Why not? If the administrative law judge will let you do it, that way you're not exposing any of your people to being cross-examined, but we're cross-examining Sally at a great time. So think about trying that. Second reason why you might not want to fight, you risk provoking a fight with Sally. Cross-examination is never fun, and if you cross-examine her at the unemployment hearing, it may make her more likely to later file a lawsuit because she's so mad about it. Sally may also have had no thought about hiring a lawyer, and then she finds out you're challenging unemployment, you're taking her to a hearing, and she may feel the need to go hire a lawyer to defend her, and that's the last thing you want to have happen. And then, actually, a negative is you might win. Sometimes the Sallys of the world, all they want is their unemployment benefits. They'll be happy with that. And if you fight them and you get them denied for benefits, it might make it more likely that she ends up filing a lawsuit. All right, responding to the personnel file request is another thing that happens after the termination meeting. Personnel file requests from former employees foreshadow that a lawsuit is on its way. Because why would they ask for their personnel file unless they were talking to a lawyer, they were thinking about filing a lawsuit. So personnel file requests foreshadow lawsuits. Interestingly, the statute in Oregon that says that Sally's entitled to her personnel records does not say she's entitled to her personnel file. It says she's entitled to personnel records used to make decisions about her employment. That could be a lot less than what's in the personnel file. It could be a lot of things outside the personnel file. When Supervisor Bob keeps that, Supervisor Bob keeps that little personnel file, his secret file, squirreled away in his drawer on his employees, well, that's within the scope of the personnel records request, so you may have to turn that over as well. Consider doing an exit interview. Nothing in the law requires that you do exit interviews, but it might be a good reason. Number 1, it could diffuse Sally. It may let her blow off steam such that she's less likely to file a lawsuit. You may learn things that Sally tells you about her supervisor and what Supervisor Bob is doing that you had no idea. So you might want to do an exit interview. Respond to job reference requests. Most employers, when they get a reference request from a prospective employer, Sally, will only respond with name, rank, and serial number kind of stuff, right? That's probably what almost all of you do. And it's because you fear a defamation claim, right? You fear being sued for defamation. And so most employers have a policy that prohibits their supervisors and managers from even responding to reference requests. My suggestion for how to handle a reference request, just get a release. Get Sally to sign a release given to her by her current prospective employer, the one she's applying to. She signs that release, and if the scope of it encompasses a release of you, that's great. Then you're covered, and you can say anything you want at that point. So think about getting a release. I also talked, it may be valid to get a release signed by Sally at the time her employment starts with you. It's not clear under Oregon law whether that's valid or not, but they'll sign anything on the first day of employment, right? So you put a form in front of them that says, I hereby prospectively waive my rights to sue if my employment ever ends with this entity, if my employment ever ends and you give a reference to me on a prospective employer, I hereby release my rights to sue for that. May be valid, We don't know under Oregon law, but it's worth a try. Sixth thing, retain the relevant evidence. You already pulled it aside, now you got to retain it. I get the question all the time, how long should I retain the records on Sally? I think there's two factors that control that. Number one is, what's the statute of limitations on any claims that Sally could potentially bring? Well, the longest statute of limitations in Oregon is 6 years for breach of contract claims. But under federal law called the Lilly-Ledbetter Pay Act, technically pay discrimination claims never run out of the statute of limitations. Every time a new paycheck is issued for less money than what the employee thinks she's entitled to, the statute of limitations basically never expires. So maybe you should keep it forever. The other factor to consider is, what's the cost? You know, in today's world, to put it on a thumb drive or a DVD or whatever, a CD, what's the cost? I had our IT person a couple months ago take 30,000 emails off my computer and put it on one CD. Well, what's the cost to preserve that? Very little. You can throw that in the personnel file and keep it. So, you know, if you can, I'd keep it forever. All right, I had a couple thoughts here about monitoring employees' electronic communications, and then I'll be done. There's 3 questions basically on monitoring employees' electronic communications, such as emails and Facebook, things like that. Number 1, can I do it legally? Number 2, should I do it? And number 3, what are the risks? So let's talk first about, can you do it? The answer is yes, you can monitor electronic communications by your employees if you notify them in advance that such monitoring might take place. So, for example, make sure your policies say a couple things. Number 1, your policies need to say that your electronic communication system and all electronic devices you give the employee belong to the employer, not to them, that the employer may monitor their use of those systems and those devices, and third, no employee can have a reasonable expectation of privacy in any of those systems or devices. If you say that in your policies, you should be protected and should be able to monitor employees' electronic communications on your equipment. So the next question is, should you do it? There's a lot of good reasons why you should. Some of them are listed there. Let me talk about this case that came out of Orange County back in 2012. Here's the facts. Espinoza was a juvenile corrections officer for Orange County. He was born without fingers on one hand. His coworkers subjected Espinoza to various forms of disability harassment on the job because of his disability. Also, while off duty, his coworkers posted lots of negative and disparaging comments on personal blogs, very offensive comments about Espinoza and his physical condition on their personal blogs off duty. Espinoza complained to his supervisor, and he identified who the coworkers were that were saying these bad things on the blogs. The county does a cursory investigation, found that numerous employees at work had accessed these personal blogs to read them, not to put anything on them, but just to read them. And the court also ended up finding that although the county had the ability to stop employees from accessing personal blogs, the county did not stop all access by employees. Basically, the county did a kind of a cursory investigation into Espinoza's allegations, failed to take any significant remedial action against the employees that were harassing him. Espinoza sued. One of his claims was that the blog posts constituted disability harassment. And he sued and he won $820,000, $320,000 for lost pay, $500,000 for emotional distress. Employer, the county appealed the decision up to the California Court of Appeals, and the county argued, hey, we couldn't be liable for these blog postings because we didn't control these personal blogs. These are the employees' personal blogs. The court rejected that argument, and the court said, wait a minute now, the employees access those personal blogs through your computer system at work, and those blogs contains discussions of work-related issues. So the court ruled basically that Orange County had a duty to stop the disability harassment of Espinoza once the county became aware of it. What's the bottom line of Espinoza? A public employer can have not just a right to monitor employee use of the employer's computer system, may also have a duty to monitor employees' use of your computer system. There's the risk of doing it. It takes time, takes money to monitor employee use. And there's a risk if you don't have the proper language in your policy, you might invade employee privacy rights. Obviously, it causes morale problems at times. I think the risk of monitoring employee electronic use is far exceeded by the benefits of doing it. Employees often raise the First Amendment as a factor. They say that their communications on the internet are protected by the First Amendment such that they cannot be disciplined for those communications. The First Amendment only protects speech by individuals acting as a citizen on matters of public concern. That may not at all be what they're doing at work. And in fact, statements made pursuant to an employee's official duties are not made pursuant to the First Amendment. Statements made pursuant to an employee's official duties are not protected by the First Amendment. Last slide I have then has to do with social media. And it basically, you may review an employee's social media as part of a pre-employment background check. You obviously cannot ask the employee for their password to the private site, but if it's publicly available, you can monitor on their social media use. And there's a couple guidelines there. The biggest one at the bottom there, either use a third party to monitor their social media use or a designated HR supervisor. If you use a third party, the Fair Credit Reporting Act kicks in if you use a third party, and you have to comply with that act, which, among other things, requires that you give notice to the employee of various things. That's it. I'm over time. Appreciate it. I'll be around to answer any questions if anybody has any down the road. Thank you.